All right, good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Ms. Bridgewater, what is the SAP reset date?
September the 13th.
Okay, thank you. And I see that Courtroom 2 is ready to go. I know it's a little before 2 o'clock. Let me give everyone a chance to get on the line.
Yeah, we got number 12 if you ready. Number
Okay.
12.
And Your Honor, just a quick announcement. I'm showing that number 9, Dominique Solis, has bonded out through the Anytime Bonding Company.
Okay, thank you, Ms. Falk. And who's representing I'm sorry, Courtroom 2. What position is this?
12, I believe he said.
Okay, who's representing Maisha Watkins? Hi, Ms. Kim, good afternoon. You're on mute. Are you representing Ms. Watkins this afternoon?
Let me check really quick, Mr. Watkins.
Cloud, right?
Yeah.
Okay.
I do not think so, Your Honor. I believe that is conflicts, but I'll go check.
Okay,
Yes,
I believe this is a conflict attorney, Courtroom 2. Can we go to someone else until Ms. McLeod or someone else gets on the line? Thank you.
Got number 9, Miss Solis.
Call her.
Oh, I'm sorry, Miss Hines.
What's the position number?
I don't know. I'm sorry.
5.
Five,
That
okay, thank you.
is,
Carla Hicks Hines, Your Honor.
yes,
Okay, position 5. Is this your case, Ms. Kim?
no, Your Honor, that is Allison.
Good afternoon, Ms.
Yes.
Whitfield.
Good afternoon, Judge. How
How are you
Yes,
today?
this is my client. Yes, I'm
Okay.
good. Thank you.
Good, good. Good afternoon, Ms. Hines. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Thank you. You have been charged in case 22 CR 005867A with battery family violence. Afternoon, Mr. Howard. Is there a history?
14 total. 2020 FTAs for criminal damage to property, second degree, theft, and theft by taking. Came off a 2019 arrest. She was arrested in 2011. I put that one in the chat. What else? Before that was 06, carrying concealed weapon, theft of property.
Okay. Ms. Falk?
Yes, Your Honor. Just by way of explanation, this was a cross warrant case. However, Mr. DeFrance Hines, who was the cross warrant that was in state court, was transferred to the felony division based on this being a second family violence battery. So the recommendation for Ms. Hicks is going to be a $3,000 signature bond, stay away from DeFrance Hines, no alcohol, drugs, or weapons. The reason for that recommendation, and I know that deviates from our normal surety bond recommendations, but the primary reason for that is twofold. The fact that this defendant has, her most recent case was that 2020 FTA and a 2019 theft by taking. Prior to that, there had not been any offenses since 2011. Additionally, there were no crimes of violence when I went over her history. However, Mr. DeFrance Hines, who was the cross warrant in this case that was transferred on a 2002 family violence battery against Miss Carla Hicks, which was Miss Hines's name prior to her marriage. So it seems that there is a long history here of domestic violence, possibly against Miss Hines, and for that reason we are recommending a signature bond until we can kind of get more information to determine how best to dispose of this case. This did happen August 30th at 3:25 a.m. The defendant came into zone 3 to report an altercation. She stated that the DeFrance Hines had been drinking and arguing with her, picked up a stick and struck her on the left side of the head. Officers could see 2 small visible knots to the defendant's head. And when they questioned DeFrance Hines, he stated that the defendant attacked him with a small blade, cutting him on the arm, and had a laceration to his arm. Both of them are residentially challenged and live in an encampment behind 2380 Metropolitan Parkway, which is why there is not a stay away order. And that is all for the state.
Do you have any objection to a signature by Ms. Whitfield?
No objection, Your Honor. No, my only request was going to be that she be allowed to return to whatever residence that she and her husband share, especially since he has been charged now with a felony, and she's seems Your Honor is prepared to grant a signature bond. But given that new information about their residence or lack thereof, I would. That was the only concern I had. Just wanted to state for the record that I believe Ms. Hines informed me that both she and her husband would like to drop the charges against each other. So no objection, Judge.
Okay, so it'll be a $3,000 signature bond through the jail. Stay away from Mr. Hines, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Hines.
As we have number 1, Mr. Bray.
Good afternoon, Mr. Bray. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, I don't mind.
Thank you, Mr. Bray. You've been charged in case 22 CR 005876Y with disorderly conduct and criminal trespass. Is there a history, Mr. Howard?
I don't have that file. Did he go to felony 2 today?
I can check, but I can give Your Honor the history. He has 9 cycles going back to 2010. His most recent conviction was a criminal trespass and fare evasion on July 27th, 2022, which he's currently on probation for. We had a disorderly conduct in May of 2022, probation violations in 2020 and 2019 on a 14 SC case, which was an armed robbery, financial transaction card fraud, and obstruction from 2014, which he was also convicted of, and then a 2019 theft by shoplifting charge.
Okay. Who's representing Mr. Bray?
It is also a conflict attorney, Your Honor.
Okay. So, Ms. Kim, if you
Yes.
wouldn't mind, tell me all the conflict attorney that you know of, who the conflict attorney cases are, so that we don't seem to have a conflict attorney at the present time, so that we don't go to people who we don't have an attorney here to represent.
Yes, Bray, Claxton, Watkins, Wilfong. I can text it as well.
Okay, thank you. And let's see, is it I'm not sure who's hosting today, Ms. Champion or Mr. Jordan?
It's Miss Champion today, sir.
Hi, good afternoon, Ms. Champion. Do we have a conflict attorney available today?
It's supposed to be Miss McLeod. She hasn't signed on yet.
Okay, would you please give her a call and let her know that we are awaiting her arrival?
Okay.
Thank you, I appreciate it. All right, so Courtroom Two, if you'll take that into consideration as we move forward. Who do we have?
Number 2, Mr. Bryant.
Okay. Good afternoon, Mr. Bryant. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Did you hear me? Hello? Can you all hear me?
I can hear you.
It just came back in. It broke up a little
Oh,
bit.
okay. All right. My question was, Mr. Bryant, do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 005878E with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
I don't have Bryant on my pull sheet. So I don't have that file.
Your Honor, Justin Bryant was an add-on. He was mistakenly sent to the DA's office and was on the felony pull sheet. Then we received notification from state court that he was going to be a misdemeanor case. And when I checked the warrants, that was correct. This is his first arrest that we are showing in the GCIC.
Okay, thank you, Ms. Falk.
Not a problem, Your Honor. So this incident happened August 5th, 2021, and it happened at 3865 Lake Sanctuary Way in East Point. Miss Loveline Bryant, and that is Loveleyne, stated that when she was having a verbal altercation with her husband, the defendant, who was her husband at the time, he spit into her face and then struck her in the face, knocking her down. Miss Bryant stated to police she blacked out, and when she came to, she went up the stairs, got their 1-year-old son, and immediately left the residence after getting her child dressed. Miss Bryant also received a CAT scan at a later time to ensure there was no internal injuries, which there were not. However, the officers at the scene were able to observe swelling to Miss Bryant's cheek and a bruise to her collarbone. We have had an opportunity to speak with Miss Bryant at the time of the offense. She stated that she and the defendant were married, but they are now divorced. They do share the one child who was present at the time of the offense. She stated that she still lives at the incident location. The defendant still lives at the incident location, and she has since moved to another residence. She has stated that she is fearful of the defendant. She fears for her safety because the divorce was not amicable. And she is concerned that this arrest may agitate things going forward. She stated that when this happened, she was unsure of how long she blacked out for, but when she woke up, she did have unexplained bruises on her body, which make her believe that the defendant continued to hit her after she blacked out. She stated she had a swollen face, bruising on her arms and her collarbone. She wants no contact whatsoever with the defendant unless it's regarding their son, and they do have contact regarding the son through the Our Family Wizard app, which we want to continue using only that app for any contact with the children. She is also asked to pray stay away from her address, but is concerned enough regarding this defendant that she does not want her address put into the order. So we are asking that there just be a stay away from the victim's residence wherever it may be. The recommendation on this case is a $4,000 surety bond. Stay away from the victim's address. 200 yards is usually what we request. No further contact with the victim, Miss Bryant, unless it's with through the Our Family Wizard app, and it is limited only to discussions regarding the child. And 1 day anger awareness and no alcohol, drugs, and weapons. The child's name is JB, and we can put that in the chat for the record.
Okay, thank you, Ms. Falk. Ms. Kim?
Yes, Your Honor. Mr. Justin actually denies all the allegations, Your Honor. Right now, he resides at 3865 Lake Sanctuary Way alone after they divorced. He does not know where Miss Loveline Bryant resides. And Mr. Justin has a custody and visitation rights from the Superior Court to visit his son. So we would like to make sure that that continues. And we are fine with a stay away, and we have no objection to no further contact either. They're completely divorced. No need to talk about it. No need to have any more discussion whatsoever. Mr. Justin has been residing here in Georgia for 32 years, and he has all his family members here in Georgia. And he graduated from Kennesaw University with a master's degree in information technology. And he's undergraduate. He has a double major, accounting and finance. He's very brilliant. And he also has been working at Google full-time employee ever since from 2019. He's a very talented person who got into Google. Nowadays, it's really hard to get in. So we would like to request for signature on bond. This is his first offense. He does not want to lose his job. He does not want to lose his life. We believe that this incident brought up 1 year later, probably because of her anger toward ex-husband who divorced. So we would like to request for signature on bond.
Okay,
Your Honor, if, sorry, if I may, I did not mean to interrupt the court.
fine.
I did not give the division of the bond that we are requesting. We are requesting a $3,500 surety bond on the family violence battery. We are then requesting a $500 surety bond on the cruelty to children in the 3rd degree. I will point out that in looking at the warrant was signed on March 28th of 2022, but it was reported, and the police report does have that it was reported to the police back in 2021. So I'm not sure what the delay was due to, but she reported this immediately to the police. This is not something that just cropped up because they were in the middle of a divorce. She reported it in a timely fashion to the police the day after she was beaten by this defendant.
Okay, thank you, Ms. Clark.
We have not had a chance to verify that actually that happened. The reporting actually happened on the incident date or right after that. We don't have a report. We don't even have a copy of the warrants for these two. Also, my client says that the child was upstairs in the stroller thing. He was 1 year old, and they were actually doing everything, talking that basement. So there was a big difference, distance from him and his child. Child was not even around. There was no psychological damage to child. So cruelty, there was no cruelty to children either. But anyway, we would like to request for signature bond. Thank you.
Ms. Bryant, I see that you're on the line with us today. This is your opportunity to speak if you would like to address the court. You're not required to speak, but if you would like to speak on this matter, you'll have to activate your camera and unmute yourself, and I'll have to swear you in. So this is your opportunity if you'd like to speak. Okay, it appears that Ms. Bryant does not want to address the court. As this is the first offense, it's going to be a $3,000 signature bond for the battery family violence, $1,000 signature bond for the cruelty to children, which is a total of a $4,000 signature bond through pretrial, 1-day anger awareness, no further contact with Ms. Bryant, stay away from her address, and third-party transfer of the child for visitation. No drugs, alcohol, or weapons while out on bond. All right, good luck to you both, Mr. and Mrs. Bryant.
Your Honor, may we please specify that third-party transfer, or that third party includes Wizard, the family Wizard apps that they are using right now?
The state was going to make the same request that it be through
Okay.
our family wizard.
Okay, that's fine. If everyone's in agreement on it, so yes. Okay, Ms. McLeod, I see you there. I know that you are in other courtrooms this afternoon. Do you have a moment free now or not? All right, it appears not. Who do we have next?
Number 4, Mr. Crawford.
Good afternoon, Mr. Crawford. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon, Mr. Crawford. You have been charged in case 22 CR 0058688E with loitering and prowling and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
This is 5th arrest. Last arrest was on the 16th of this month. FTA for battery DV, battery disorderly conduct, out of DeKalb County. He was arrested in April in Henry County. Fleeing an officer, obstruction, felony theft by receiving, driving without a valid license. The possession of a firearm was dismissed. March 2020 battery DV out of the cab. So that was the initial arrest. 2018 simple battery dismissed out of the cab count. So he just got the open case. That's it.
Okay, thank you. Ms. Falk?
Yes, Your Honor. This happened August 30th at 12:24 p.m. Officers were initially called out to a suspicious male breaking into vehicles in the parking deck at 485 Lindbergh Place Northeast. We did look at that address up. It appears to be either two apartment buildings or apartment buildings going by two different names. The Point at Lindbergh and Willow West at Lindbergh are the names. And a description was given to the police of the defendant. The officer observed a defendant matching that description looking into a white Honda Civic in the parking deck. Officer gave chase. The defendant fled, and they were yelling, "Stop, police." They were finally able to catch up with the defendant as he was running away from them. They were able to speak to Mr. Tim Baker, who was a resident of the apartments, who stated he was parked and was going into his apartment when he saw the defendant looking into a silver Mitsubishi Outlander. And he stated he had not seen the defendant around before. He was mildly alarmed, but became more alarmed when he saw the defendant notice him and then pull his shirt up to conceal his face. And at that point, Mr. Baker became concerned enough that he went ahead and just called 911. The defendant does, as pretrial has pointed out, he is on his 5th cycle. I will point out that the defendant is only 21 years of age. And so we have 4 cycles already since the age of 17. The DeKalb FTA on August 16th, the April 2022 theft by receiving and fleeing and eluding out of Henry, and then that 2022 arrest for battery, family violence in DeKalb, which he then picked up the FTA on August 16th. So we're already off to a pretty dismal start with both FTAs and new offenses and new arrests. For that reason, the state is recommending a $3,000 surety bond. We are recommending $1,500 surety bond per count due to that history and the FTA. We are also asking for no further contact with Mr. Tim Baker and a stay away from the address at 485 Lindbergh Place, known as both the Point at Lindbergh and Willow West at Lindbergh. We are also asking for no alcohol, drugs, or weapons. That is all.
Thank you. Ms. Whitfield?
Yes, Your Honor. We're asking you to consider Mr. Crawford's financial situation. Above all, he absolutely cannot afford to post any bond at the moment. We would ask for a signature bond, or in the alternative, no more than $500 per surety bond per charge. There was no allegation of violence committed with this obstruction charge toward any officers, so it's something else for Your Honor to consider. Yes, Mr. Crawford is 21 years old. While he is originally from the Savannah area, he's been living in Atlanta for the past 6 years. He has been living with some roommates here. He did not graduate from the 12th grade. However, he will be, if he's released, he will be, he's due to start school again full-time soon. He is not employed at the moment, especially in anticipation of returning to school full-time. And Your Honor, I do not believe he lives at the apartment complex, so we would not be opposing the stay away.
Okay, so I'm sorry, Ms. Whitfield, just is he or is he not in school? He's not in school at the present time?
He's not in school at the present, but he will be as soon as he is released.
And has he been in school in the recent past?
I don't believe so. I'm not sure if he has, maybe within the past 6 months or so. I'm not sure.
Okay.
But it is his plan to return.
And is he not working?
No, you're right.
All right. All right, so it's going to be a $500 good bond on each charge, making for a total of $1,000 good bond. No further contact with Mr. Baker. Stay away from 485 Lindbergh Avenue, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Paul.
And number 6, Mr. McCrimmons.
And Your Honor, is there going to be the no further contact with the witness, Mr. Baker?
I believe I said that, but if I didn't.
I apologize if I missed it.
Okay, you're fine. Yeah.
Thank you, Your Honor.
You're welcome. Mr. McCriven, good afternoon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, yes.
Yes, good afternoon, sir. You've been charged in case 22 CR 005875E with simple battery family violence. Is there a history, Mr. Howard?
14 total. Last arrest was 2019. Cruelty in the second. Cruelty in the first. These are FTAs. Ag battery, ag assault, DV. He's on probation for that as of 2020. They gave him 5 years probation. For cruelty in the first, ag assault, ag battery, 16 SC 147448. What else? 2019, carrying a weapon without a valid license, theft by a season. Those were dismissed. 2016, that's the cruelty in the second. 2015, failure to appear. Another 2015 FTA, 2014 FTA. Another 2014 FTA, 2012 probation. That's it.
Thank you. Good afternoon, Mr. Dudley.
Good afternoon, Your Honor. This incident took place on June 10th of 2020 at 3144 Martin Luther King Jr. Drive Southwest, where the defendant entered the victim, Jasmine JAZZMYN Tramel's apartment without her permission. The defendant walked into her room and asked her to unlock her old cell phone. She told him that she couldn't help him with unlocking the phone, and the defendant got angry and punched her in the right arm, pulled her hair, and threw her wallet at her. Ms. Tramel was able to call 911. The defendant then punched her TV and left with his belongings before officers arrived on the scene. This incident occurred in front of her 4 children. As pretrial pointed out, the defendant was convicted of aggravated assault and cruelty to children in the first and second degree in 2020, where the events took place in 2016. He entered a guilty plea on January 8th of 2020. Although this was with a different victim, he was on probation due to that conviction. Just 5 months later, he batters Ms. Tramel in front of her children for not being able to unlock a phone. And he's here again before the court. I suggest that, something didn't stick with this defendant. He has an issue with keeping his hands to himself. And that gives the state serious concerns that he has a risk of reoffending. As it was also mentioned, he has multiple FTAs and probation violations, which gives the state concern that he is a potential flight risk. So we're going to recommend a $3,000 surety bond, no further contact with the victim, a stay away from the incident location, no alcohol, drugs, or weapons, and a 1-day anger awareness course. Nothing further from the state.
Do we know why it's been taking more than 2 years to get him picked up on this, and when he's been on probation?
To the state's knowledge, no, Your Honor.
I mean, it would seem to me that if you were prosecuting him, or if he was being prosecuted for this aggravated battery, that it would come up that he had this charge pending. That's just a question. Ms. Whitfield?
Your Honor, you echo my sentiments exactly. We'd be asking for a reasonable bond, as low amount as possible, in light of Mr. McCrimmon's history. He does share 3 children with Ms. Tramel, 3, 1, and 9 months old. They are no longer together. They do not live together anymore. Mr. McCrimmon, I'm sorry, do you have a question? They do not live together at the moment, so he has been living with his father, so we do not oppose a stay away. However, he would ask that he be allowed to, of course, co-parent with his with her. They have been they've spent the last 2 years since this alleged incident with no issues whatsoever. So we would be asking for third-party custody or perhaps no violent contact with Mr. Trammell, or Ms. Trammell. He has lived in Georgia all his life. All of his family, friends are here in Atlanta, especially, like I said, including his father. He completed his GED. He has been working 2 jobs for about 6 months now. He's been during his daytime, he's been driving for Bulldog Movers, and for the past couple years, he's been working at a nightclub, doing sort of a everyman job, security, bar back, whatever the club needs. So we'd be asking for as low a bond as possible, no more than $1,000. He would like to get out and go back to work and be able to provide for his children.
Okay. Mr. Dudley, did your victim advocate speak with Ms. Trammell?
Our victim advocate reached out when we were unable to reach the victim.
Okay, thank you. Ms. Whitfield, again, your client has his hand up.
Yes, Mr. McCrimmon, do you have a question about the process? We can't go into the facts of the case right now. I would advise you not to do that.
Okay, that's fine.
Okay.
All right. So it's going to be $1,000 good bond. Since no one has spoken with Ms. Trammell at this point in time, it's a no further contact with Ms. Trammell, although it seems that given that they have a 9-month-old and a 1-year-old, and there are no reports of any additional incidents since 2020, that they have been seeing each other, but it's this court's normal practice that unless either party speaks with Ms. Trammell, that there's a no contact order in place. If someone does speak with her and she would like to have contact, then I would certainly agree to a modification if necessary. Third party transfer of the minor children. Stay away from the 3144 MLK Drive address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. McCrimmon.
Thank you, Your Honor.
Thank
You're
you.
welcome.
I just got number 7, Mr. Roberts.
Good afternoon, Mr. Roberts. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Mr. Roberts, you've been charged in case 22 CR 005865B with simple assault, family violence, and terroristic threats and acts. Is there a history, Mr. Howard?
Yeah, all of his history come out of Virginia. He had a 2019 assault and battery conviction. Last arrest was 2020 probation violation. 2012 strangulation. It was non-pros. 2012 probation revocation. Possession of a controlled substance conviction, 2007. Yeah, everything else is like in the 90s. That's it.
Okay. Mr. Dudley?
Yes, Your Honor. This incident took place on August 31st, 2022 at 901 Bolton Road Northwest, where the defendant told the victim, Anita Harrington, common spelling, that if she didn't get her belongings and leave the house, that he was going to beat her ass. Miss Harrington's sister, Valerie Harrington Swain, overheard the defendant saying the threat over the phone, and Miss Harrington felt in fear of her life when the defendant threatened her. The two are married and they live together at the incident location. We were able to speak with Miss Harrington, and she stated that the defendant has been violent with her in the past. The defendant was arrested in Virginia for choking her in 2022. She has called the police on the defendant about 4 months before this incident for punching her in the face, but that did not lead to an arrest. The victim stated that she wants to file for divorce and wants no contact with the defendant and to stay away from the resident. The defendant's probably going to need a one-time law enforcement escort to retrieve his belongings. And from our contact with her, it did not appear she would be on Zoom, but we would still sound for her. Based off what the victim told us, about her previous violent encounters with the defendant. The state has a serious concern about his risk of reoffense and the fact that the bulk of his history is out of Virginia, that he may have a lack of community ties. The state is going to recommend a $3,000 surety bond, and the breakdown on that is going to be $1,500 for the simple assault family violence, $1,500 for the terroristic threats and acts, no further contact with the victim, a stay away from the incident location, and 1 day anger awareness with no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
Thank you, Ms. Whitfield.
Yes, Your Honor. Mr. Roberts is 59 years old. Yes, he is originally from Virginia. However, he's been living in Atlanta for the past 2 years with his wife. He has indicated to me that if the court imposes a stay away, and I understand that the state has spoken to the complaining witness in this case, that he really does not have anywhere he can go if he is, like I said, if the court imposes a stay away. He is a high school graduate. He has been working for the past 2 weeks as a laborer at Mahler's Zeal. He really needs to get back to work. He is very concerned about losing that job after only starting for the past 2 weeks, Your Honor. So we'd be asking for a reasonable bond, no more than $1,000 for the simple assault and $500 for the terroristic threats, surety bond. I'm aware of his history, especially with this particular complaining witness, Your Honor. So that would be our request.
All right. If Anita Harrington's on the line and she wishes to speak, now would be your opportunity. I don't see her on the line, Mr. Dudley. As such, the bond is going to be for the simple assault, a $1,500 good bond, for the terrorist threats, a $1,500 good bond, making for a total of a $3,000 good bond. No further contact with Ms. Harrington. Stay away from the Thornton Road address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Roberts.
Thank you, Your Honor.
And as we have number 8, Mr. Shaheed.
Good afternoon, Mr. Shaheed. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, Your Honor. Yes, I do.
Thank you. Mr. Shaheed, you have been charged in case 22 CR 005866C with battery family violence. Is there a history, Mr. Howard?
We got like 19 total. Yeah. 2013 battery dismissed. Before that, it says 02. So he got a violent history. The stuff is old, but he hasn't been convicted for anything. Everything's been dismissed. Well, record restricted anyway, but that's pretty much how I can sum up his history. I'll let the state go in depth.
Okay, thank you. Mr. Dudley?
Yes, as it was mentioned, he was arrested for a lot of criminal offenses that were dismissed. They go back pretty far. To start in 1989, he was arrested for murder. That was dismissed. Battery in 1993, simple battery in 1994, simple battery in 1996, battery in 1997, battery family violence in 1997, and battery family violence again in 1998, along with the battery in 2013. Each were dismissed. Your Honor, this incident took place on August 26, 2022 at 3295 Elm Street. The defendant was angry with the victim, Asantewa, Asantewa, Abdur Rabani, common spelling, for allowing a friend to spend the night. The defendant then grabbed Miss Rabani and threw her on the ground. He struck her in the back of her head with a closed fist multiple times. After striking her, he grabbed her by the neck and threw her onto the bed before throwing her off of the bed again. After throwing Ms. Rabani off of the bed, the defendant grabbed her by the back of her head and proceeded to slam her head into the ground before leaving the scene. Officers who arrived observed bruises on both arms of Ms. Rabani as well as her neck. Your Honor, the two are married and live together in a location. Our victim advocate was able to speak with the victim, and the victim stated that they are married, they live together, they share no children. She stated that she wants no contact with the defendant and to stay away from the residence until she's able to pack her belongings and leave. She stated that she would need until Sunday. The victim stated that the defendant during this incident put his knee on her jaw, and he stated that the defendant also put her in a chokehold. She is on Zoom today, I presume, and we should sound for her. Your Honor, at no point should an argument escalate to this level, let alone between a husband and his wife. And for events like this to take place, it's more than likely that it's not the first time that it's happened. And without proper action, it certainly won't be the last. The state has concerns of the defendant influencing the witness due to the fact that they are married, and concerns that the defendant will intimidate the witness due to the defendant being arrested so many times for those violent offenses and having them dismissed. That typically screams that that's the result of witness intimidation. Your Honor, the state also has a concern of risk of reoffense, as the defendant has been arrested multiple times for those violent offenses. We're going to recommend a $5,000 surety bond, no further contact with the victim, a stay away from the residence until Tuesday, September 6th at 9 a.m. And then the defendant must have a law enforcement officer escort him to ensure that the victim is no longer at the residence, no alcohol, drugs, or weapon, and a one-day anger awareness. Thank you. Nothing further from the statement.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Elijah Shaheed is 50 years old, and he's been here in Georgia for all his life. He has a total of 10 children, and 6 of them are minors, and he has been paying for child support, and he's been supporting those 6 children as well. He has a limousine service business for the last 18 years. He's self-employed, and he provides for the family. He graduated from high school, and we do not have any objection to return on September 6, 2022, 9 a.m. After we verify that wife does not reside there. As long as that happens, we can go there. And we don't have any objection to no further contact at this point either. I think bringing up 1989 is very prejudicial to my client, and I totally object to that one even being mentioned. And also, just because the cases were dropped, that does not mean he intimidated witnesses at all. Since there will be no contact, there will be no intimidation of the witnesses as well. So we would like to request for a signature on bond. I believe that he's qualified. Thank you.
And Your Honor, just to clarify the record, I would like to put their spelling of the victim's last name on the record, which is Abdur, A-B-D-U-R, Rabani, R-A-B-B-A-N-I.
Thank you. Ms. Rabani, I see that you're on the line. This is your opportunity to address the court if you would like to. You are not required to address the court, but if you would like to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in.
You said I have to show my face?
Yes, ma'am.
I'm just really shocked.
Okay, Ms. Rabani, you're gonna have to activate your camera for me.
Sorry.
All right, you can take your time, ma'am. Okay. And I take it that you're pulled over, is that right?
Yes, sir.
All right. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Ma'am? Ms. Rabani?
Hello, can you hear me? Yes.
It appears that you're frozen. So did you answer yes to my question?
Can you hear me?
I can hear you now. I couldn't hear you earlier. Can you hear me?
Yes, sir.
Okay. Do you swear affirm to tell the truth?
Yes.
Okay. What would you like to tell the court?
So my husband and I have been married for a few months. We met at our religious service, a place of prayer, and to hear that his history is so extensive. I mean, I'm I'm 29. I'm 29 years old. So to hear that his history has been so extensive, just even before my
Miss
time,
Rabani, it
and
seems
the things that I'm dealing with really
Miss
just
Rabani.
confirms that this thing that has been going me in like community spaces and things like that, which he's very active in. And
Ms. Rabani, can you tell me about what you want me to know about the incident, please?
I can't hear you.
Okay, you're in a bad location. You have bad connection. We can't hear you very well either.
I'm sorry, I can't hear you. I'm sorry, give me 1 second. Okay.
All right, so tell me what you want me to know about the incident.
So basically my husband has another wife. He didn't come home that Thursday night, so I invited two of my
May I please raise objection? Can we limit her testimony to just whether she's afraid of him and whether she wants the contact or not? Thank you.
Okay, in this court, I allow both sides to offer witnesses that I'll listen to and judge it on the weight. Go ahead, Ms. Rabani.
So my husband didn't come home the previous night, and I told him, okay, whatever. So I had two of my friends come over. We just moved into our house over here. So I sent him a message and told him that, hey, one of my friends is going to be spending the night. He didn't respond back to the message. So he comes home in the morning and asks me, oh, how did you guys' night was? And I was like, oh, it was fine. So I told him, I said, also my other homegirl, she came over too. And he was like, why didn't you tell me that she spent the night? I mean, why didn't you tell me that she came over? I was like, well, I didn't really think that it was a big deal because only one person spent the night, not two people, only one person. And he was like, oh, so this is the type of wife that you are. You don't want to communicate or inform me when people are coming over. I can come in and out anytime I want to. And I'm like, well, I wasn't expecting you to come back because you said you was already out with your other wife. So moving on from that, my friend leaves and he's laying on the couch. This is about like maybe like 8 a.m. or so. He's laying on the couch and I asked him, I was like, why are you always upset with me? Like, why are you always mad at me? Like, this is not fair. Like, I didn't do anything wrong to you. You're always mad. You're always upset. So then like he just jumps out of the bed. I mean, jumps off the couch and was like, I don't have to deal with this, and starts getting dressed. I'm like, this is just so ridiculous. Like, this is not fair. I'm dealing with all of your emotional ups and downs. And it's like, this is becoming very hard for me. So we're in the bedroom at this time, and I'm in his face, and I'm not yelling, but I'm like, why are you always so angry with me? So then he proceeds to get closer to me and was like, fuck you, get out of my face, and just start cursing and just talking to me, demoralizing me and talking to me so crazy. So I smacked him. And this is like 3 weeks after us losing our baby. And he has said some of the most craziest, hurtful things to me that I've ever heard in my entire life. And this is my first time being married. And it's like, you're going to be fuck you and screaming at me all the time in my face. I felt like, what am I to do? So then from there, it was like, as if he was holding back this energy, and it just, everything just transpired from there. And at
Okay,
this,
Ms. Rabani, I take it that you're afraid of him and you don't want him back in the residence. Is that correct?
I do not want him back in the residence, but I'm leaving. If this is where he pay his bills, he can live here. He's closer to his children, but I'm okay. I'm just gonna go to my dad's house, and
The court has already been informed that you'll be out by September 6th at 9 o'clock. Is that accurate?
is that 9 a.m. or 9 p.m.?
The court was informed that it was 9 a.m., but you tell me when you're gonna be out, and I won't have him come back until you're not at the residence anymore, if that's what you want.
Yes. If I can have until the evening, on Tuesday, that would be great. I do know that his car is here, so pretty sure he needs a vehicle, but I am here.
Okay, so I'm gonna give you until Wednesday, September 7th at 9 a.m. If you say you can be out by the evening of Tuesday, I will not have him come back there at any time before Wednesday, September 7th at 9 a.m. And he's gonna have to come with law enforcement to make sure that you're not there. All right. And
I don't know where he's going to be, but if he's at his other wife's house, it's literally 5 minutes from our house.
He's not going to have anything to do with you, and if he does, then he's going to be in violation of my order. So it doesn't matter as long as he's not around you where he is. Okay.
Okay.
All right. Thank you, Ms. Rabani. Good luck to you, ma'am.
Thank you.
All right, counsel. Anything further?
Your Honor, I would like to point out that she confessed that she smacked him first. So first aggressor is her, and my client is not the first aggressor. Thank you.
Anything further, Mr. Dudley?
Nothing further from the statement.
All right, it's going to be a $3,000 good bond. No further contact with Ms. Rabani. Stay away from the Elm Street address until Wednesday, September 7th at 9 a.m. He can go back to that address at that time, but he's going to have to ensure that Ms. Rabani is not there. As such, he's going to have a police escort take him there. And no drugs, alcohol, or weapons while out on bond.
Your Honor, can he have another one-time visit to get his car before?
If he needs to get the vehicle prior to September 7th, as long as there's a police escort and that he does not have to bother Ms. Rabani, then he can go back and retrieve the vehicle with a police escort.
Thank you.
All right.
Yes, Your Honor.
All right. Good luck to y'all.
Your Honor, was that a $2,000 surety bond?
It was a $3,000 surety bond.
Thank you, Your Honor.
Okay. All right. Who do we have next?
Number 10, Mr. Staff, Mr. Sylvan.
Yes, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Excuse me. Do you agree to have your case heard by video? Mr. Sylvie, did you hear me?
No.
Do you agree to have your case heard by video?
Yes, sir.
Okay. You've been charged in case 22 CR 0058711Y with expired or no license on person and giving false name or information to law enforcement. Is there a history, Mr. Howard?
23 total. August 19th, DUI and FTA. These were out of Fayetteville. He was arrested back in May for robbery by snatching, giving false name out of Valdosta. 2021 April out of Colquitt County probation. Trespass, family violence, 2021 out of Fairburn. 2019 probation. 2017 probation. 2016, 2015, same thing. He got first offender for simple battery DV out of Valdosta. He's a resident of Valdosta. He has a hold too. Out of Moultrie, Georgia. That's a probation violation. That's it.
Okay. Mr. Dudley?
Yes, Your Honor. The defendant was also arrested earlier in 2022 out in Valdosta for giving false name, address, or birth date to law enforcement officer. This incident took place on August 21st of 2022 near Clay Street and Bay Street in Fairburn, Georgia. The defendant was driving while unlicensed, and when pulled over by law enforcement officers, he gave the police a false name, stating his name was Jonathan Slive, and gave a fake birth date of July 9th, 1996. The defendant was later identified by his girlfriend, and it was revealed that he used his brother's name. The state is going to recommend a total $1,000 surety bond, with the split being $500 for the expired or no license on person and $500 for giving a false name or birth date to a law enforcement officer. No alcohol, drugs, or weapons, and no driving without a valid license. Nothing further from the state.
Ms. Kim?
Yes, Your Honor. He is 28 years old, and he was born and raised here in Georgia. He has one child that he's taking care of, and he has siblings here in Georgia. At this point, he has no job right now because he was incarcerated last 3 months at Fairfield County. So there's no money for him to pay any bond. And his highest education is 9th grade. And please, we request for a signature on bond for those 2 charges, so that way he can go and take care of another warrant at another foreign county. Thank you.
All right, it's going to be a $250 good bond per charge, makes a total of a $500 good bond. No driving without a valid license, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
All right, we got number 11, Mr. Torrance.
Good afternoon, Mr. Torrance. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do. Good afternoon.
Thank you. You have been charged in case 22 CR 005872C with simple battery family violence. Is there a history, Mr. Howard?
His third arrest. 2011 misdemeanor possession of marijuana. It was later dismissed. 2006 battery, simple battery DV, dismissed.
Okay, Mr. Dudley.
Yes, Your Honor. This incident took place August 4th of 2022 at 951 McKay Drive. The defendant got upset, or the victim, Demiya, Demiya Gates, mother, Demetria Gates, and her boyfriend, the defendant, got into a verbal altercation over the clothes that her mother was wearing and the fact that she would not change. The defendant got upset and he and the victim's mother went into the bedroom. The victim could hear a loud commotion coming from the room. When she walked into the room, she saw the defendant on top of her mother, and she ran to help her mother. The defendant grabbed her by both her arms and started shoving her outside the room. Once out of the room, she could still hear the loud commotion in the room continue. So she got her brother, and her brother ran back into the room to try and help her mother again. And the defendant grabbed her once again and shoved her out of the room. We were able to speak with the victim's mother, Demetria Gates, and the victim's mother stated that her and the defendant are no longer together, and the defendant no longer lives at the residence. She stated that the defendant and her have not had any contact since the incident, and the defendant has no reason to have contact with the daughter, Miss Gates. We also were able to speak with the victim's father, Anthony Jones, and the victim's father stated that he does not want his daughter to have any contact with the defendant. And the victim is 14 years old, Your Honor. Both parents will be on Zoom, presumably. Given the relationship that existed or exists between the defendant and the defendant's mother and the defendant, the state has concerns that the defendant will influence this witness. Your Honor, this type of incident should never rise to the level of violence where a child has to witness her mother being attacked. And then when she tries to intervene, which no 14-year-old should have to do, is grabbed and shoved away, forced to hear her mother continue to be attacked because she wouldn't change her clothes. The state is going to recommend a $3,000 surety bond, no further contact, a stay away from the incident location, no alcohol, drugs, or weapons, and a one-day anger awareness course. Nothing further from the state.
Thank you, Ms. Kim.
Yes, Your Honor. Mr. William Torrance is 35 years old, and he has been here in Georgia for 27 years, ever since 1995. And we have no objection to stay away and no further contact whatsoever. He has no reason to meet DG minor, and he has not had any contact with DG mother as well. They broke up, so it is what it is. And Mr. Torrance they used to even have a food truck business together. However, because of breaking up, he has not had any employment either, because it's in his name, but he stopped business as well. And his highest level of education is high school graduation. He does not have to visit 951 McKay Drive whatsoever because he has no personal belongings there. And Your Honor, I would like to mention that he turned himself in when he found out that there was a warrant outstanding. He just turned himself in to take care of this matter. And he denies all those allegations that husband of his ex-girlfriend made. We believe that he's qualified for signature on bond since all those old remote cases were all dismissed, Your Honor. There's no conviction whatsoever. Thanks.
Let's see, I see Ms. Demetria Gates on the call. Ms. Gates, if you would like to address the court, now is your opportunity. You are not required to address the court, but if you do want to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. Okay, it does not appear that Ms. Gates would like to address the court. As such, it's going to be a $3,000 signature bond through pretrial, one-day anger awareness, no further contact with Demetria Gates, Demaya Gates, stay away from the 951 McKay Drive address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Torrance.
Did you say anger?
Yes.
Thank you, Your Honor.
I'm gonna circle back to number 12, Ms. Watkins.
Okay. Good afternoon, Ms. Watkins. Again, I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, everybody. Yes, sir, proceed.
Thank you. You've been charged in case 22 CR 005873A with false report of a crime. Is there a history, Mr. Howard? First arrest, okay. Mr. Dudley?
Yes, Your Honor, this incident took place on August 30th, 2022 at 1371 Kimberly Way. The defendant made contact with Officer Riviera, who was dispatched to the location based on a call from the victim, Jihad, G-I-H-A-D, Rashid, common spelling. The defendant claimed to be the girlfriend of Mr. Rashid. She stated Rashid was upset due to a disagreement and he pulled a firearm out on her. She stated he then took their car and left the apartment complex. She stated they had been dating almost 2 years on and off, that it wasn't love, it was lust. The defendant also stated she wanted to press charges and did not feel safe. After bringing Mr. Rashid to the City of Atlanta's Zone 4 precinct, Mr. Rashid stated that the defendant was not his girlfriend, but his girlfriend's daughter. Mr. Rashid stated his girlfriend was Nicole Mallory. Officer Riviera had Officer Carter go back out to the incident location and made contact with the defendant, who repeated the same story and then stated that she did not claim she was Mr. Rashid's girlfriend. And then the defendant inevitably confessed to Officer Carter and stated that she made the whole story up. The state recommends a $3,000 signature bond through pretrial services, no further contact, and no alcohol, drugs, or weapons while out on bond.
Good afternoon, Ms. McLeod. You have any objection to any of that? You're on mute, Ms. McLeod.
Do I, to what the state has related? My client has a different narration of the facts, Your Honor. She tells me she was actually—
They are asking for a signature bond.
A signature bond, I'm fine with that, Your Honor.
Okay, that's what I was asking. If you have any objection to a signature.
No, I have no objection to the signature bond.
Okay.
But the facts are a little different.
Okay, I understand. So $3,000 signature bond through the jail. Stay away from Kimberly Way address, no further contact with Mr. Rashid, and no drugs, alcohol, or weapons while out on bond.
Your Honor, the living arrangements, this is her place. And her mom and her boyfriend were staying with her.
Oh.
This is her home.
Are they still there?
I believe that they are still there, Your Honor.
Well, that's a problem because I wouldn't want to be staying with someone who had allegedly reported me to the authorities. Well, she can go back to that address if Mr. Rashid is not at that address. If Mr. Rashid is at that address, she's going to necessarily have to go somewhere else because she's to have no contact with Mr. Rashid.
I understand, Your Honor.
Okay, so if Mr. Rashid wants to leave, then he can do that. But otherwise, she's going to have to find somewhere else, and she can have a one-time escort to either retrieve her belongings or to verify that Mr. Rashid is not at that address before she goes back. Okay?
Thank you, Your Honor.
All right, good luck to you, Ms. Watkins.
And Your Honor, to clarify the spelling of the victim's last name, it's going to be R-A-S-H-E-E-D.
B as in boy?
D.
D, okay. Okay. Who do we have next? Sorry, tell me again.
Number 1, Mr. Bray.
Okay. Good afternoon, Mr. Bray. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
It does, Your Honor.
Thank you. Mr. Bray, you've been charged in case 22 CR 005876Y with disorderly conduct and criminal trespass. Ms. Falk, sorry, I have to ask you to begin again. I know that you have given some of the facts.
No worries, Your Honor. I know Ms. McLeod was, had a conflict in another courtroom, so I'm more than happy to start again. So this defendant has 9 cycles going back to 2010. A criminal trespass and fair evasion conviction is his most recent conviction, and that is on July 27th, 2022, for which he is still currently on probation. The defendant also has a disorderly conduct arrest from May of 2022, probation violations in 2020 and 2019. That was on a 2014 conviction, 14 SC conviction in Fulton County for armed robbery and financial transaction card fraud, as well as obstruction, and then a 2019 arrest for theft by shoplifting. On this date, on August 30th, the defendant was at the Waffle House at 135 Andrew Young International Boulevard Northwest. He was harassing customers, refusing to leave, and generally causing a disturbance. The officers then arrived at that location at the behest of Gary Greer, that is Gary Grier, who stated that, and he was the manager of that location, who asked that the defendant not return. The officer advised the defendant he could not return, and the defendant walked outside. While he was talking to the officer, the defendant stated he was not leaving the location, that he was going to join the military and get something to drink from that location. So after the defendant walked outside, the officer got into his vehicle, and as he was leaving, he received a call back to the location that the defendant had re-entered, was refusing to leave, and was in a verbal altercation with a customer. The officer went back, observed the defendant using profanity and threatening customers, and at that point, the officer had no choice but to place the defendant under arrest. So the current bond that's already set on this is a $2,000 surety bond, $1,000 per charge. We are asking that that bond remain the same. We are further requesting a stay away from the Waffle House at 135 Andrew Young International Boulevard Northwest. No further contact with Gary Greer, no alcohol, drugs, and weapons. And based on the interaction alone, so I can't base it on anything else other than what I observed based on the warrant and the police report, we are going to ask for a BHET. We just have some concerns based on the interaction with the officer.
Thank you, Ms. Ball. Ms. McLeod?
Yes, Your Honor. My client is 29 years old. He is unemployed. I would sign on to what the state said about the BHET because my client really needs some help.
Okay.
And he's not working at all. He's unemployed. I don't think he's able to work, Your Honor, given what's going on with them.
All right, so in that case, I am going, since you are both in agreement, I'm going to order the mental health evaluation, and
yes, Your Honor.
It'll be a $2,000 good bond, $1,000 per count. Stay away from the Waffle House. No further contact with Mr. Greer, and no drugs, alcohol, or weapons while out on bond. And if you can get that order to Ms. Bridgewater, I'll get it signed.
I will prepare the order, Your Honor.
Okay, and Courtroom Two, I know that Mr. Bray has his hand up, but Mr. Bray, you have the right to remain silent. Anything that you say can be used against you. But I do want to give him the opportunity to speak if
yes, Your Honor. It probably is a good thing for the court to hear him speak.
Yeah. Hey, listen, my name is Jesse Christopher Bray. I was running for mayor. I told the mayor to take a polygraph test for treason and cut talking. He got scared, got nervous when I kept bringing up Polari. And
okay, thank you, Courtroom Two. Thank you, Mr. Bray. Okay. If you want to deal with that, Courtroom Two, when you have, we'll move on to the next person. Thank you. And also, if, as we normally do in the future, if you will bring this to my attention so that we don't have to do this live on YouTube, I'd appreciate it.
Yes, Your Honor.
Yes, Your Honor. I was requesting a BHET. I did not know the extent, and so I apologize for not doing this.
You're fine. I'm not trying to chastise anyone. I'm just want to preserve his rights.
Oh, I got number 3, Mr. Claxton.
Okay. Good afternoon, Mr. Claxton. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're doing by video. Do you agree to have your case heard by video today?
Yes, yes.
Thank you. Mr. Claxton, you've been charged in case 22 CR 005870G with simple battery and simple battery in a public transit vehicle or station. Is there a history, Mr. Howard?
Fifth arrest. He was arrested in April in Mississippi. Controlled substance violation. Illegal possession and fraudulent possession of a controlled substance. Hold on. January 2020 in Georgia, possession of drug-related objects, possession of a Schedule 1 controlled substance or narcotic. 2018, possession of drug-related objects. 2014, suspended license. That's it.
And Your Honor, given that there is going to be a request by the state in the same vein as the last request, I would request a breakout.
Okay. Let's see. Do we have one more in courtroom 2, Mr. Wilfong, position 13?
Yeah, we do.
Let's do Mr.
That's my
Wilfong.
client as well.
Let's do Mr. Wilfong so that we can, before we go into a breakout, so that when we come back, we'll be done with the calendar, okay?
Yeah, we'll come back to you.
What happened with number 9?
It's my understanding that number 9 bonded out.
And Mr. Howard, we're having she bonded out through any time bonding company based on the jail record.
Good afternoon, Mr. Wilfong. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Thank you. Good afternoon. Mr. Wilfong, you've been charged in case 22 CR 005874Y with battery. Is there a history, Mr. Howard?
21 total. 20 in New York, Ohio. Last arrest was 2015 out of New York City. Obtaining transportation without paying. Trespass in the 3rd degree. Conviction. Another 2015 obtaining transportation conviction without paying, of course. 2010, same charge. Criminal mischief, intent to damage property conviction. 2006. Let me find the Ohio history. Last arrest in Ohio was 2001. Came off of stalking. That's all.
Okay, thank you. Who's presenting for the state?
That will be Mr. Dudley.
Is this position 13?
13, yes.
Okay, Your Honor. Yes, I'm ready.
Okay, go ahead.
Your Honor, the defendant and the victim, Eric Walker, were in a verbal argument. The defendant came home and told Mr. Walker, "I'm going to kick your ass for fucking with my car." The defendant punched Mr. Walker in his face. Their other roommate, Charles Shannon, witnessed the entire incident. Officer Bouquet observed the left side of Mr. Walker's face was swollen from being punched in the face by the defendant. The defendant has a total of 21 total cycles, 13 cycles out of New York, mainly 15, 6 cycles out of Ohio, 2 cycles in Georgia. Given that the bulk of his criminal history is from New York, some out of Ohio, that gives the state some concerns of his lack of community ties. We're going to recommend a $4,000 surety bond, no further contact, stay away from the incident location, which is 1580 Childress Drive Southwest, and no alcohol, drugs, or weapons, and a 1-day anger awareness course. Nothing further from the state.
Your Honor, my client is 63 years old. He denies the allegations as stated by the state. In fact, he tells me that the complaining witness was the aggressor. He actually lives he moved down here recently from Ohio. For the past 4 months, he has a job working as a forklift operator. He tells me that he's currently living in a rooming house situation and that the complaining witness drinks a lot and is usually disturbing the peace. The complaining witness confronted him and hit him first. They were having an argument and the complaining witness struck him first and he defended himself, and that was all that occurred, Your Honor. He doesn't have a lot of money because he just moved down here, just started his job to post bond. His history is nonviolent, as the court heard from pretrial. I would ask the court to consider giving my client a signature bond, Your Honor, given his age, his circumstances, the fact that he is presumed innocent here, and that he denies the allegations made by the complaining witness.
Okay. Mr. McLeod, I'm gonna give him a signature bond, but he's gonna have to find another rooming house to stay in. So it's gonna be a $3,000 signature bond through the jail. No further contact with Eric Walker. Stay away from the 1580 Childers Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. And no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Okay. Good luck to you, Mr. Wolfram. Okay, and so I think the last one will be Mr. Claxton. So we'll go into a breakout room to discuss Mr. Claxton.
Let me give you this open case record.
Okay, thank you, Mr. Howard.
Superior Court case 20 SC 174-686. Possession of cocaine and drug related objects. That's it.
Any other convictions?
No, that's open, but no, not outside of what all the judges.
Okay. All right, so Ms. McLeod, Ms. Falk, myself, anyone else need to be, and Ms. Bridgewater? Okay. Okay, and so Mr. Claxton, Courtroom Two, this is Mr. Claxton that we have before us. Courtroom Two, you're on mute. And I'm just verifying, this is Mr. Claxton that we have before us?
Yes.
Okay, thank you. Mr. Claxton, I've had an opportunity to discuss your case with your counsel and the state. The present bond is a $3,000 good bond for the simple battery, a $2,500 good bond for the simple battery in a public transit or vehicle. Those bonds will remain in place. They're both good bonds, making a total of a $5,500 good bond. You're to stay away, no further contact with Ms. Tamika Williams. Stay away from the MARTA station at 30 Alabama Street. No drugs, alcohol, or weapons while out on bond. And there will be a mental health evaluation and treatment and referral to mental health court. Okay, and we believe that that can be done by tomorrow.
Your Honor, just to let the court know, those two bonds were, the 3,000 was on the simple battery on transit, the 2,500 was on the simple battery.
Okay.
And Your Honor did do this, no further contact with Ms. Willis?
I did.
Okay, thank you.
Okay. Good luck to you, Mr. Claxton. All right, Courtroom Two, I believe that concludes today's calendar. Thank you so much.
Thank you.
Have a good one.
And Your Honor, I did get a message from MH Court. Because we have not yet had full agreement from Ms. Willis, they are not going to see her tomorrow. So I will ask our victim advocate to try to get in touch with Ms. Willis again, just to see if we can get some response from her as to whether or not she is okay with us going forward.
Okay, thank you, Ms. Falk. All right, anything further before we go over the calendar?
So does that mean he won't be on tomorrow?
He will not, because the MH Court is, from my understanding, they require at least some feedback from the victim. And so because we have not been able to reach her, we did attempt it, but she has not responded yet. We will go back and try again.
So will I get notice when he is going to be on?
I can ask that you be looped in on any emails regarding his case.
Okay, thank you.
I'll put that in the email right now. Thank you.
So in the meantime, is he gonna go to the SAP calendar?
Well, I think the calendars are he should be on that calendar by the following.
Which is the 8th, yes. So my hope is it possible, Ms. Bridgewater, that we can put him down for the 13th, and then if he's seen on the 8th, that will kind of take him out of the loop. But if something happens and he's not, then we'll make sure we catch up with him.
Absolutely, no problem. With that being said, are we ready?
Yes.
Okay. Once again, the reset date for the SAP calendar is going to be September the 13th. Position number 1 is going to the SAP calendar with a $2,000 total good bond. Position 2 is reset further notice with a $4,000 total SOB through pretrial. Position 3, which we just heard, is going to be reset to the SAP calendar with a $5,500 total good bond. Position 4 reset to the SAP calendar with a $1,000 total good bond. Position 5 reset further notice with a $3,000 SOB through the jail. Position 6 reset to the SAP calendar with the $1,000 good bond. Position 7 going to the SAP calendar with a $3,000 total good bond. Position 8 going to the SAP calendar with a $3,000 good bond. Position 9 bonded out, therefore is being reset further notice. Position 10 reset to the SAP calendar with a $500 total good bond. Position 11 reset further notice with a $3,000 SOB through pretrial. Position 12 reset further notice with a $3,000 SOB through the jail. And position 13 reset further notice with a $3,000 SOB through the jail. Any questions, comments, or otherwise? No?
Okay,
All
thank you
right
all.
then.
I appreciate it.
Everybody take care.
Okay, I'll see you all next week. You all have a safe holiday weekend.
Thank you,
Oh,
Judge.
that's
You
right.
too.
Thank you, you
Yeah.
too.
Okay, thank you.
All right. Bye-bye.
Bye, everyone.